Welcome to the Competition Law Observatory lecture on competition law and communications. This lecture is being recorded in February 2013 and is therefore current to February 2013. You should have in front of you some slides that have been circulated separately, and I will be referring to the slides as I go through, because competition law, as applies in the communications sector, requires sometimes an understanding of different regulatory interaction and interaction sometimes between competition law and regulation. And I think it's actually easier to understand that by reference to the slides that should have been circulated separately. So if you just move to the first slide, which is numbered 2 there, the very first thing to bear in mind is what do we refer to when we talk about communications. Traditionally, the sector was preponderantly referred to as telecommunications, but in recent times, due to the advent of convergence, mostly, communications really includes not only the traditional telecommunications area, but increasingly content provision and dissemination over different platforms. So different platforms can actually provide the same content and often use telecommunications infrastructure. Moving on to slide number 3, you will see that this particular lecture is structured around 2 main areas: the procedural aspects and the substantive issues. Slide 4 will start the section on procedural aspects. And if you move to slide number 5, you will see that the fact that competition law and regulation, particularly telecoms regulation, overlap gives rise to institutional complications, because 2 sets of regulators could in principle be responsible to deal with a similar situation. To complicate matters more, in some countries such as the UK and Ireland, the regulator, the communications regulator, has concurrent powers with the National Competition Authority to apply competition law to the communications sector. So procedurally, there is a little bit of a difficulty in the interaction between different authorities. Now the next slide, number 6, deals with a schematic representation of regulation, which is often considered to be ex ante, and competition law, which is often considered to be ex post. And the point made there is that Ofcom prefers to rely on its competition law powers rather than its regulatory powers if faced with a situation that could be dealt with by regulation or competition law. Ofcom is, of course, the regulator for the communications sector in the UK. If we move to slide 7 now, it's not just the fact that at the national level there could be a competition authority and a regulatory authority that may complicate matters, but of course there is an interaction between the national level and the supranational level. So that, for example, in Europe we have 2 authorities, DG Competition and what used to be known as DG Information Society and is now DG Connect, are really 2 different regulators at the European level that deals with aspects of competition law and regulation in the communications sector. And as it says here, each has the task of applying to the same target group, the communications sector, 2 different legal frameworks, competition rules and regulation, which in some respect overlap. So, in slide 8 and 9, you will see a table of the different layers of regulation that at a procedural level apply. And of course, the European Commission is DG Comp, but is also DG Connect. And the national competition authorities would, of course, apply national competition law. and the NRA in some countries will apply competition law and regulation. There are then these bodies such as BEREC, the body of European regulators for electronic communications, which of course are an extra layer which is in between the national bodies and the European Commission. I do not propose to go through the table in detail because you have it there and you can have a look at it, but it's just to give you an idea of the complexity. And with that, we move to the second part, which is the substantive analysis. This starts on slide 11, and interestingly, communications is often the first sector in which competition law is introduced. So it is the case that in jurisdictions as diverse as Hong Kong or the Bahamas or indeed Bahrain, in some cases there are no generally applicable competition laws, or like in the case of Hong Kong, a generally applicable competition law has just been introduced. But the communication sector has had a set of competition rules applicable to it for a number of years prior to that. Even in the UK, it used to be the case prior to the introduction of the Competition Act, 1998, that there was a fair trading condition in BT license that Ofsted, the predecessor to Ofcom, could actually enforce as a regulator, and that it gave Ofsted the powers to intervene for breach of the competition rules by way of enforcement of a regulatory condition. So you see the interaction between regulation and competition law is present from the very beginning. So moving on to slide 12. Slide 12 is really a very dramatic representation of what competition law deals with. And you can see that as being organized in 3 boxes. On the left is anti-competitive agreements, in the center is merger control, and on the right is abuse of a dominant position. The 3 boxes are roughly intended to charter the progress from a position of competition in a market to a position of monopoly on the right-hand side, so that therefore in relatively not concentrated markets, what competition law is concerned about is, of course, the prevalence of anti-competitive agreements. But if mergers are allowed without scrutiny, a market will become concentrated very quickly, and therefore merger control is there to prevent that. And of course, even though there may be rules against anti-competitive agreements and rules that should prevent the consummation of a merger that would lead to a substantial lessening of competition, still it is possible that some companies may find themselves in a dominant position, and then there are rules against abuse of a dominant position for relatively concentrated markets. So each of these situations will be considered in brief in the next part of this talk. Of course, you know, we are not here concerned with the basics of competition law, so we will just touch upon those aspects that are of more interest in the context of a talk dealing with the communications industry. So moving on to slide 13, that's really a representation of a vertical agreement, and it's easy to get confused in the communications sector, where vertical issues are often an issue because an incumbent operator may be vertically integrated between wholesale and retail. But the vertical integration of an incumbent operator is an issue with abuse of a dominant position, is not an issue between anti-competitive agreements. And it's rare that a vertical agreement will be caught in by the rules on anti-competitive agreements in the sector. And there is little case law or decisions of the authority which will be of specific interest in the case of vertical agreements. There is some more that concerns horizontal agreements, and this is slide 14, and you will see there that a preoccupation of competition authority has always been with infrastructure sharing agreement. There the example was a T-Mobile and O2 infrastructure sharing agreement, whereby in the UK T-Mobile had the right to roam over the O2 infrastructure, and there was a parallel set of agreements in Germany, where O2 had a parallel right to roam over the Deutsche Telekom network. And the two were actually notified to the European Commission and led to two decisions, the final decisions that the European Commission issued before Regulation 1/2003 came into force. And interestingly, the European Commission then took the view that the agreement would have been anti-competitive, potentially, but that an exemption could be granted for a number of years if the parties met certain conditions. What happened then was that in the German decision case, Deutsche Telekom actually appealed the decision of the Commission to the court, to the European Court, and the European Court found that the Commission had erred because, in fact, the Commission had not properly considered the counterfactual in this case. In other words, the agreements were not anti-competitive under Article 101.1 and deserving of an exemption under Article 101.3 necessarily, but what the Commission should have asked was whether the agreements were anti-competitive at all, because of course if it is the case that the counterfactual will be that in the absence of the agreement, then the introduction of 3G, which was the point at that time, would have been delayed, then an infrastructure sharing agreement could be pro-competitive rather than anti-competitive, and therefore not fall under the prohibition in Article 101 at all. So that's quite an important case and shows how the issue of anti-competitive agreements amongst operators in the communications sector needs to be approached with care, because the sector is simply moving so fast, new products are coming in all the time, and something that could look anti-competitive in a more mature market could actually turn out to be pro-competitive if it speeds up the adoption of a new technology or the adoption of a new product. The other reason why horizontal agreements are not so much of an issue in the communications sector are listed in slide 15, and the point being that the environment is highly regulated, and although there are fora and meeting of industry participants, very often it is the case that a regulatory person will be present at this fora for a discussion on the regulatory system. Having said that, there is this famous case where a meeting, again is a T-Mobile case in the Netherlands, where a meeting of the mobile operators in the Netherlands at which the level of commission to be granted to distributors was discussed, was considered to be potentially an instance of a cartel. So, operators need to be careful when meeting, especially if there are only 4 or 5 of them in an industry such as the mobile industry, and they are discussing confidential information such as the level of a commission. So, moving on to mergers and joint ventures, which is the second category in this diagrammatic slide. It's interesting that prior to 2000, the European Commission had adopted 6 blocking decisions in broadcasting out of only 13 decisions blocking mergers. So, it looked for a time as if the European Commission was really intent in blocking mergers in the communications sector, broadly considered. But the situation has changed since. First, because the understanding of the sector has increased. There have been more than 250 cases reviewed in the telecommunications sector alone. Because the Commission works closely with the national competition authorities and the regulator, so there is greater understanding of local markets, and there is a greater willingness to engage to deal with complex cases in phase 1. So in T-Mobile and Orange, when T-Mobile and Orange merged to form Everything Everywhere, undertakings or commitments by the parties were accepted within 5 days. So there was quite a lot of work undertaken before going to the authorities, and then the merger could be resolved quite quickly in phase 1. What is also interesting in terms of merger control is that because merger control is forward-looking and so is regulation. There is some similarity between a regulatory measure and a commitment that the parties accept as a condition for entering into a merger. So that very often if a merger is considered problematic and some commitments are required, such as in the case of the creation of everything everywhere, the remedies that one tends to see in the communications sector tend to be similar to remedies that one would see imposed by a regulator, things to do with interconnection, access, and similar. What is also interesting is there at the bottom of slide 18, and in this case Deutsche Telekom, Rom Telekom. There were some foreclosure concerns that were being voiced in relation to Deutsche Telekom's acquisition of Rom Telecoms in Romania, and the regulator there, the competition authority there, said that regulation will continue to oblige Rom Telecom to provide call origination access to other operators. So the remedies imposed by the Romanian regulator consist of cost orientation, non-discrimination, transparency, and accounting separation. Because there was a regulatory system that allowed for cost orientation, accounting separation, etc., then the merger could go ahead. But of course the criticism to that is that it entrenches the regulatory system, because if the regulatory system then went away in the hypothesis, then does it mean that the merger becomes anti-competitive, and then will it be too late to do anything about that? So one would always have to be careful in trying to justify a merger or trying to say that a merger should not give rise to concerns because of the existence of a regulatory system, because of course the regulatory system could change in the future. So that's an interesting overlap. The next slide, which is slide 19, takes us to abuse of a dominant position. And it's really perhaps the most interesting area that competition lawyers dealing with the communications sector encounter. Because look at that arrow again. If the system works as it is supposed to work, in other words, if anti-competitive agreements are captured at an early stage, and mergers are not allowed to go ahead if they could lead to a substantial lessening of competition, then one would find that only in certain specific cases there could be an instance of a company being in a dominant position. And what are these instances? Well, two main cases spring to mind. One is the situation where a company has been privatized. So, like British Telecommunications is privatized, and of course British Telecommunications has the network to which competitors need to interconnect in order to provide their services. So, a situation where a company can find itself in a dominant position is on liberalization of a sector, which is of course one of the areas that we are most concerned about here on telecommunications. But the other area would be on the exploitation of intellectual property rights. So if there is a technological breakthrough, then a company will find itself in a dominant position, not least because a patent is a monopoly. And so again, we find that the communications sector is characterized by a number of issues surrounding the application of intellectual property rights, not only because of the technological breakthrough. So if one considers the communication sector could also include IT companies such as Microsoft, of course, there are the issues surrounding the technological breakthrough of a Microsoft that comes to the market and revolutionizes the way in which people operate with their computers. But also the exploitation of IP rights on the content side, so that if, say, football rights, the availability of football rights drives take-up of pay TV, then of course having exclusivity over football rights may give a company a dominant position in a particular area. No prizes for guessing who that company may be. So we are not really going to talk about abuse of a dominant position in detail. We don't have time for it. But there are four main areas that are of particular interest in the communications sector and which have been pinpointed for the final part of this talk. Predatory pricing, margin squeeze, time and bundling, and then a new category of abuse, which is abuse of the regulatory system, which would appear to be particularly interesting in the context of a sector characterized by such wide-ranging regulatory oversight. So then, predatory pricing. Well, competition lawyers will know about predatory pricing, and I would direct you straight away to the table on slide 24. And there you will see that the rule on predation that applies in Europe is the so-called AXO rule. And of course that traditionally will tell us that when the price is below average variable cost, then there could be evidence. The fact that a company is actually pricing a product below average variable cost by itself is evidence of predation. If a company prices a good above average variable cost but below average total cost, then there is a need for evidence other than that to suggest that predation is involved. So, for example, an intention to exclude a competitor will be required. When a company prices above average total costs, of course, there is no instance of predation involved. That's really the traditional AXO rule. What is interesting is that this year, actually at the end of last year, there was this post-Denmark case. And in post-Denmark, two things happened. One is that the European Court, the Grand Chamber of the European Court, has now considered that LYRIC, the long-run incremental cost, which has been long used as the measure for costing in the telecommunications sector, has to be the preferred measure in industries such as post or indeed telecommunications, which are characterized by common costs and capital costs that are often large and cover a range of services. But the other thing is that the predation analysis that the court endorsed in post-Denmark is that when it comes to pricing a particular good above average variable cost but below average total cost, what is important is to consider the actual or likely exclusionary effect of the pricing policy. So it is not so much whether there is an intention to be predatory, it's whether there is at least a likelihood of effects of the pricing policy that would lead to foreclosure of competitors. So it's a kind of interesting development, and it is interesting that it happens in post, that like telecoms is characterized by common costs, and heralds really perhaps a different approach going forward to predatory pricing. The other area where competition law is applicable to the communication sector is particularly interesting is the area of margin squeeze. So what is a margin squeeze? We are going back to this idea that vertical issues are important, particularly in the telecommunications sector. So if a vertically integrated incumbent operator provides the input in the form, for example, of interconnection that a competitor requires in order to compete at the wholesale level, and at the same time competes at the retail level with the new entrant, then it will be possible for the vertically integrated operator that receives effectively two income streams You can see I'm using my pencil to actually mimic the slide 27 really there. So for the vertically integrated company that receives two income streams, one at the wholesale level and one at the retail level, to actually engage in something similar to predatory pricing at the retail level, because of course the vertically integrated company can cross-subsidize losses at the retail level, so that the competitor that doesn't have an income stream at the wholesale level and indeed needs to purchase the input finds itself margin squeezed at the retail level, although strictly speaking the company that is vertically integrated is not really engaging into any particular activity at the retail level that would be considered anti-competitive. So what happens there is that the downstream competitor cannot really compete against the vertically integrated operator. And if you go to slide 28, you see there the elements of a margin squeeze that need to be present for margin squeeze to be found. And there needs to be dominance upstream, in the sense that the upstream input needs to be essential to competitors, and the downstream margins need to be unprofitable either because the wholesale prices are excessive, or because the retail prices are predatory, or because of a combination of the two. And the practice needs to be substantive enough to harm competitors. There is a difference then between the European Union and the UK, in that the UK puts more emphasis on actual effects of harm, whereas the European Commission is perhaps more willing to go along with a theory of harm that posits that the effects could be harm to competitor could be just a likelihood of harm. And that probably explains why there haven't been any cases in the UK of margin squeeze in the telecommunications sector. Interestingly, there are a couple of cases in the pharmaceutical sector, but not in the telecommunications sector, whereas at the European level, most cases of margin squeeze actually are in the telecommunications sector, and I think of Deutsche Telekom and Telefonica. At the bottom of slide 28, you will see this reference to Telekomunikacja Polska, which is a case where the Commission fined the telecoms operator in Poland for abuse of a dominant position because of a squeeze on competitors that is not pricing related, but what the Commission found in the case of Telekomunikacja Polska was that the Polish operator actually was obstructive, and so that it was delaying requests to have access to the network, and that it was engaged in practices whereby customers would be disadvantaged if they were customers of a competitor, etc. So it's not necessarily the case that a margin squeeze would be determined by a squeeze on price. It could be a squeeze on conditions of supply or quality of supply. And that's all really I wanted to say on margin squeeze. And just move to time and bundling, which is of particular interest in the context of triple play and quadruple play. We've been in a situation where big communications companies have been offering triple play packages and increasingly quadruple play packages for a number of years, but now is probably the time where the strategy is crystallizing the most. And of course the companies find that a customer will be less likely to switch if the customer is actually subscribed to a package of 4 services or 3 services. So the customer is sticky, and at the same time customers may like it because of convenience of purchasing it all in a package and because of price, of course. That means, of course, that an operator that can only offer one element of a triple play package will potentially be foreclosed. And so there are no real cases on triple play and quadruple play that I could pinpoint as being particularly interesting, but of course time and bundling have been a feature of competition law and abuse of dominant position cases. And so it may be worth just going through at a high level the main principles that apply to tying and bundling. First of all, and I'm looking at slide 30, tying refers to the practice of requiring customers that purchase one product, the tying product, to purchase from the dominant undertaking an ancillary product, the tied product, in a related market. Bundling occurs where a dominant operator licensee only offers its key products in bundles with ancillary goods which are not intrinsically linked to the key product. So, if the products could be supplied separately and they are supplied tied or bundled and other suppliers are foreclosed, that could constitute an abuse. And you know, the Microsoft Windows Media Player case is there at slide 31. And you know, the European Commission there found that Microsoft was dominant in the provision of Windows and was acting anti-competitively by bundling Windows Media Player with Windows, and the remedy there was to provide a version of Windows without Windows Media Player. One questions how effective the remedy was, but you know, it is a precedent to suggest that one has to consider issues of tying and bundling, particularly with triple play and quadruple play, with care. And the final category of abuse that is particularly interesting in the context of a talk on competition law in the communications sector would be the new, what is a relatively new category of abuse, abuse of the regulatory system. Now, the case here is AstraZeneca against the European Commission. What happened there is that AstraZeneca, and I'm looking at slide 33, was found to have abused its dominant position in the market for proton pump inhibitors by misleading patent authorities and misusing the regulatory system in order to prevent generic competition against its anti-ulcer medicine. So the allegation there, which has in fact been upheld by the courts, the General Court and the Court of Justice, so you know, we have a full approval of the appeal system at the European level, signals that if there is a regulatory procedure in place which is designed to achieve a certain result, in the case of AstraZeneca, the entrance of generic manufacturers after the period of expiration of a patent, then it is not open to, in this case, the patentee, but to a company in a dominant position to try and play the regulatory system so as to obtain an unfair advantage. It is really not easy to see how this could apply to the communication sector, other than to say that a dominant player that considers or finds that by manipulating the regulatory system in a certain way they would obtain an advantage should be careful and wary of doing that because of the AstraZeneca precedent. So I just wanted to point that out in the context of this talk. And this takes us to really slide 34, which really takes us to this idea of the overlap between what is known as ex post competition law and what is known as ex ante regulation. Now, you know, it is useful to think of ex ante regulation and ex post competition law in the sense that a regulator would consider a market, find that there is perhaps a market failure issue in a particular market, and decide to regulate prior to the issue becoming so complicated or so entrenched that competitors are put out of business. So therefore, ex ante. And it's useful to think of competition laws being exposed, because if there is an allegation of an anti-competitive agreement or an abuse of dominant position, then of course something has happened and the system intervenes to stop that from happening and to punish the companies that are engaged in the anti-competitive behavior. However, you know, it is not as clear-cut as that. We've already mentioned that in merger control cases, competition rule is applied, in fact, ex ante, in the sense that a merger will be considered prior to consummation, and therefore the competition authority will be looking at whether that particular merger may lead to a substantial lessening of competition, or in the case of the European Union, a substantive impediment of effective competition, apply the SIG test. And of course, therefore, that is an ex ante application of the competition rules. At the same time, a breach of a regulatory condition could be punished by a fine, and that would be an ex post application of the regulatory rules. So it's important to be aware of that. But what is also important is to consider that there is a real area of overlap where a competition authority could intervene applying the competition rules, and a regulator could intervene applying the regulatory rules, and a regulator which has concurrent powers with the competition authority could decide which way to go. And in slide 35, there is a little table there to suggest that regulation in the telecoms sector is often known as SMP regulation, significant market power regulation. So only companies that are found to be in a position of significant market power will be regulated if there is a need to regulate. And SMP, or significant market power, is defined exactly as dominance. So, it's an area where a company could be regulated because it has significant market power and there's a market failure, or it could be found to have abused a dominant position because it has this position of dominance and has acted in a way that is anti-competitive. And a remedy under SMP regulation could be price controls, but of course if a company in a dominant position is found to have engaged in collusive or dominant pricing, a remedy can be imposed under the competition rules to stop it from engaging in it going forward. And of course, often in the case of SMP regulation, what is really regulated is access to a network. Of course, access to a network and refusal to access could be a case of abuse of a dominant position by refusing access to an essential facility. So, the area of overlap is there, and it's important to bear that in mind, although of course we didn't have time to explore it in any more detail. And I just want to flag it and to thank you for your attention. And we have come to the end of our talk. Thank you very much.